Welcome everybody. People are still joining, so I use this time just for some housekeeping. My name is Stefano Feltri. I'm a journalist working with the Institute for European Policy Making, and I'm here just to introduce the webinar. This webinar has a relevant story to us because it's connected to two projects that we have been publishing on our website. The first one is a major report that we published a few months ago, coordinated by Professor Francesco De Carolis, which is titled Rules That Empower. And it's a multidisciplinary project conducted with some economists, some scholars from Toulouse School of Economics. And the idea is to give some practical policy recommendation and a theoretical framework to make European rules for the digital industry more effective. And as the title suggests, the approach is that rules are important to promote innovation and are not simply an obstacle to innovation, as some big tech CEOs argue quite often. The second project that we want to discuss today is something more specific. It's a policy proposal which is fully aligned with the idea that the IEP is a policy accelerator for academic research. And this is a policy proposal for actually helping digital platform to reduce the harm that they might cause to users. So the webinar will be structured in the following way. We'll have two of three authors, Oreste Pollicino and Tommaso Valletti, who will give us the context of this policy proposal, and then we'll have Dove Vlavi, who will get into the details. Then Maria Teresa Maggiolino will help us as a discussant, and then we finally have an actual policymaker who will react to this proposal. So let me just introduce our speakers. Oreste Pollicino is a professor at Bocconi University, and he is one of the co-author of the report, especially of the part focused on digital constitutionalism. Tommaso Valletti is an economist. He works at Imperial College and is former chief economist at DG Competition in the European Commission. And Dove Vlavi is a professor of management in Bocconi at the Department of Management and Technology. And Maria Teresa Maggiolino, she is also one of the author of Rules That Empower report, and she is a professor of antitrust law at Bocconi University. So she's an expert also in digital regulation. Then we have Luca Aguzzoni, who is head of sector DMA team at the DG CNCT at the European Commission. Basically, he's the person in charge of the Digital Markets Act, which is one of the major pieces of legislation we discuss in the report, because it's one of the most important innovation in terms of a preemptive regulation that try to prevent digital platforms to make damages rather than trying to correct them ex post. Okay, at the end of this discussion, we will have plenty of time for Q&A, so please write your question in the chat or ask to intervene, and we will find a way to give you the floor. Okay, with no further ado, I give the floor to Oreste and Tommaso for setting the stage for the policy proposal.
Excellent. Thank you very much, Stefano, for hosting this webinar. I will start and then I will pass it on to Oreste. So the webinar is based on a recent paper that Oreste, Dove, and I have just published online. The title is on the main slide, and we just published it in the Academy of Management Perspective. It is an academic paper, but we really try to speak to a very important policy question, and that's why the webinar is very important to us. So it's an academic paper, but I should say for all of us that we don't have any conflict of interest to disclose related to this paper. It's about digital platforms. The paper and our proposal is about the problems that we're encountering with big tech. In my couple of minutes, I will say that as a summary of our way of seeing things, when you think about the digital platform, it's a long period of already 30 plus years that we have experience. In the first half, the first 15 years until about 2010 were a period of a lot of competition, of disruption, of innovation, and all the brand names we are familiar with came out in the late 90s and early 2000s. But then from 2010 onwards until now, so it's another long period of 15 years, things changed because of the economic nature of technological platforms. Winner takes it all, or winner takes it most, network and effects, and huge sunk cost. The digital platforms have become incredibly concentrated. So a couple of examples are important. Google, since at least 2010, has had in excess of 90% market share in search worldwide, essentially, and certainly in the European Union. Similarly, Facebook has dominated in the past 10, 15 years display advertising. And while becoming dominant, for instance, Facebook revoked the ability of users to choose their privacy policies. So things happened. We realized with some lag that this dominance was arising. We as a society, as institutions, we ran antitrust cases. This is my disclosure. As you said, I was chief economist of DG Comp until 2019. So we had, for instance, 3 cases against Google. These cases took a long time, many years. They were sound from a legal point of view in the sense that they survived in court. However, from an economic point of view, from a business point of view, I mean, by the time we decide on these cases, competition is dead. And it's very difficult to resuscitate those dead bodies that have been left back over the years. This slide has the harmful practices of many of these digital platforms. Some of those will be within the realm of antitrust. Some will be in the realm of consumer protection. Some are actually externalities that business practices have on society at large. The way we inform ourselves, the way we read news, the way we communicate. So these are a novelty, perhaps, of these platforms is not the market power they have, but the power and the speed, the reach that they have. This is unprecedented, and also the supranational nature of the problem. So, and in the past, we have had a dominant corporation, but they were within the national boundaries of certain countries. Even the big trust in the United States in the late 19th century that gave rise to the antitrust legislation were within the US. So they had to negotiate something with the constitutional powers of the country they were operating in. Instead, this is really transcending national borders, and this is new. So we went through a reflection on our ex-post approach with competition policy, which we will continue doing, of course, but it has limitation. And Europe in particular has started rather quickly to propose ex-ante approach. And this is all instruments which need to be still used, but as we argue in the paper, they are not going to be enough. And now I'm going to pass it on to Oreste to tell us more about the legal problems that the new tools might still face. Oreste.
Yeah, thank you very much, Tommaso. And I mean, you already said a lot also in terms of relevant frame, which is the relevant frame from my side. And by the way, Stefano, this is something that in a way connects the 2 projects that you mentioned before. Why? Because in that report, there is a reference in the title of the solitude of antitrust, the splendid solitude, and the need also to ask for a little help for some friends, in this case, constitutional law. What do I mean? I mean basically that exactly as Tommaso said, there is a kind of transformations of these actors from economic actors to private powers. What does it mean, private powers? It means basically the need to deal with a different kind of power. I'm not saying that antitrust is not any more effective at all. Clearly, there is a crisis within antitrust in the etymological sense of need of transformation. No, a Digital Market Act, but I'm not at all expert on this. We have a great expert is part of this game, even though you can clearly object that the DMA is an antitrust tool. It solves an antitrust tool. But what I want to say with specific regard this point, there are clearly some issues that despite the good intentions of the regulators, which is the good intentions, which is the goodwill, to try to face this new season of digital constitution, of digital private powers, with much more effective tools. One of these tools is the Digital Service Act. No, the other one is the DMA. Which is the problem here? The problem is that basically these procedural dimensions can create, as you can read, some negative externalities, especially as far as the fragmentations is concerned, especially as judicial interpretation is concerned, especially as far as the as you can see here, the need of, in a way, trying to not delegating to very large platform the basically main task to assess content moderation, not only in the light of their constitutional European values, but you know very well that this kind of moderation will be done also in the light of their own standards in terms of condition. What does it mean? It means a delegation to private powers of a task that should be, in a way, in the hands of public powers. It means there a risk, basically, to give too much discretionality to the large platforms. I don't know, but I will end then passing the floor to Dove with these questions. That is not a rhetorical question, but it's a real important question. In this kind of, let's say, inconsistency that I tried to let emerge, are we sure that without what we propose as further added value in terms of certification, are we really sure that very large platform will be able to be effective at the same time fair when there will be a task at stake? And the task is the following. It's not only to deal with illegal conducts, but with legal or lawful but harmful. You know very well what I mean, no? Something that is not considered at all unlawful, like disinformation or hate speech, but has a harmful effect on society. You know, this is really the point that, at least from a constitutional point of view, make me worry and make us think to something a little bit more effective in order to not for sure reset, but diminish the potential and effective harms. Dove?
Thank you very much, Tommaso and Oreste, for setting the ground. I am sure that everyone who's attending this webinar is well familiar with the problem, the overall agony of the big tech firms and the harms they cause to consumers, business users, society. And many of us are also familiar with the limitations of regulations. So we don't elaborate on this in the webinar. There is plenty of information discussed in the paper itself. Let us introduce our proposed original solution. This solution doesn't replace antitrust or regulation. It complements them, but it complements them by overcoming some of the weaknesses of these available mechanisms. Certification means that we are specifying a standard for desirable business practices, but also identifying undesirable business practices, and then using a scorecard checklist that are being assessed with an independent third-party organization And to the extent that they complete the process, they receive certification. Now, as example of such certification, you can think about the ISO 9000 certifications for management quality systems, or the B Corp certification for governance and sustainability. And these are some relatively successful certifications that have had major impact. But you must be wondering, why would the big tech and other dominant platforms seek to certify themselves if this would just expose their weaknesses? So the idea here is that these platforms have incentives not to certify. They have incentives to disguise their business practices, to avoid the remedies of regulation. So we need to go more in depth and look not only at the business practices, but actually at the algorithms of these digital platforms. Now, you might be wondering, why would these big tech platforms share access to their algorithms? Well, the DSA and DMA already require such access under certain circumstances. We are just suggesting making it a default as opposed to a rare occasion. And these algorithms can tell us the true nature of the business practices. They can expose the real meaning of these practices, even when the companies are trying to disguise them. This would not replace the review of the business practices, just complement it to get a more full understanding, to reduce information asymmetry, to enhance transparency, and reduce uncertainties related to the microprocesses of these digital platforms. So the idea is that you will have a team of an inspection team by a third-party organization that would go and inspect documents, information systems, conduct interviews, will examine the software code, the model specification, the training data, if it is AI-related, run queries on the algorithms of these platforms in their premises, and will use scorecards to assess both the presence of harmful practices, but also identify desirable practices that these platforms pursue. So in this process, after identifying some issues of concern, the inspectors will provide feedback to the company, what they need to do in order to improve and pass the certification items in the next examination, would provide them with a benchmark so that users can examine the different platforms and assess how much they serve their interests and how much they are appealing to stakeholders. And as much as this can, let's say, undermine the legitimacy of some digital platforms that are not pursuing the public interest, it can enhance the reputation of those that do. So the inspection would be done by a third-party organization. It could be either the ISO model, an international body, or a specialized private organization like the B Lab. And this would by itself allow us to overcome the geographical and jurisdiction limitations that Oreste mentioned with respect to the existing regulation, because you can apply the same inspection process regardless of geographical location. The inspection and the certification are completely voluntary, so digital platforms don't have to go through it, but then if they don't, then they are disadvantaged. The team has to be multidisciplinary. It has to have expertise in computer science, legal affairs, some business practices, operations. So it would be an interdisciplinary team that would be able to provide a whole insight into the business practices of these digital platforms. What should be the governance of this inspection organization? We discussed this in the paper. There are pros and cons to different structures, but given the urgency, we suggest relying on an existing certifying organization, like taking the B Lab and expanding its existing scope into the domain of digital platforms, because they already have the resources, tool, reputation, which is very important. And if you are concerned about why would the platforms share information, and given the risk of spillover of their intellectual property, there are existing established procedures to amending this or dealing with this, like in the case of the ISO 27001, which exposes some trade secrets, but there are practices to minimizing this risk. So the process itself involves going with a scorecard. One scorecard would be for the do no harm practices, which correspond to the 10 harmful practices that we identified in the paper. And then we'll have a scorecard for do good, which could rely on the Sustainable Development Goals, only that they will be applied or adjusted to the context of digital platforms. The advantage of this approach is that every time you identify a new type of harm, you can update the scorecard, and in the next review, which will probably be annual, you can already examine for the presence of that harmful practice, as opposed to regulation, where it takes years to identify the problem, then to incorporate it in regulation, then apply it. This will be a much faster adaptation to evolving realities and additional harms that are being developed. So if currently the let's say the business model innovation of the digital platforms is much faster than regulation, this is a way to catch up with these dynamics. So you might be concerned about the scope of this investigation, but it doesn't mean that you need to inspect the whole platform and whole of the practices. You can, just like ISO certification, go and look at selected practices, and you can have some tips, either anonymous tips from employees, or you have some academic think tanks that would identify problems. And the assessment is that even if it's an AI-based platform, the cost would not be more than 2 to 5% of the system, and you can adjust the certification cost to the platform size. So the smaller platforms will actually be subsidized by the big tech companies who will pay higher fees. And in fact, you can make certification even free to the extent that you are assigning the fines that currently the big tech companies are paying to that purpose. So it's not just money that goes to the government where the stakeholders do not benefit. In the case of certification, the public, the users directly benefit from the certification process because they have access to information, they can make informed decisions, and they also can see how the fines are being channeled to a productive purpose. So with respect to the motivation of adopting the certification, we are not delusional. The big tech firms not only will not rush to certify, they will try to kill those that try. So here the idea is to have an indirect pressure. Currently, there is a negative pressure, penalties, regulatory intervention, but here there is positive motivation for firms to certify. So small platforms, contenders that currently have hard time competing with the big tech will have a source of differentiation advantage. They will be able to show that they are better than the big tech with respect to certain dimensions, such as serving stakeholder needs, using the certification. So the small contenders will join first in order to increase their market share, draw customers, business partners, etc. And once the market share of these small contenders is large enough, then the big tech firms would try to recapture it. And some of them might also change the practices and opt for the certification. So the contenders would certify first, but it would be the network externalities that would reinforce the adoption and mostly the competitive pressure on other platforms that haven't certified yet to join, because if you join late, you don't benefit from differentiation. So there is a pressure to be among the first to certify compared to your competition. For this to work, the public, the stakeholders need to recognize the value, the quality of the certification, which relates to the reputation of the certifying body. In the paper, we discussed several scenarios for how the certification system is likely to be adopted, and we consider sometimes the possibility of government intervention or the regulatory intervention to force the big tech companies to certify, to the extent that the voluntary certification will not be sufficient. But the regulators will not do that before the certification becomes sufficiently reliable and gains some reputation in the public. So in any case, the small contenders are the ones that would start, and maybe the governments can provide support to startups, to small companies that are able or willing to certify as an incentive in addition to the market benefits of it. So I will not go into depth into the merits of certification versus regulation. It's very clear that the focus here is on positive incentive, increasing your market share as opposed to regulatory penalties. It's clear that here we are talking about ex ante measures to adapt your practices to meet certain aspirations as opposed to ex post penalties. And the focus here is not only on the practices that are forbidden, but also on practices that are desirable. And here we are providing incentives to pursue these desirable practices and also identify harmful practices that are not forbidden, because we don't need to just identify the extreme cases where there needs to be regulatory intervention. We also want to identify some small challenges that these platforms cause and then incorporate this in the scorecard during the assessment. So we have more on this on the paper. I just want to emphasize that whereas the regulation assumes that there is a misalignment between the business interests of the digital platforms and the public interest, here we create a system that aligns together these interests because it's in the best interest of the digital platforms to serve society, because this will increase their market share, will draw some customers. Not everyone. We can imagine that some some digital platforms would prefer to offer efficient, fast, cheap service without certifying, and some customers would opt for that. But those who do care about their data privacy, care about their consumer welfare, etc., they would prefer and have a choice to go with certification and certified platforms. So the focus here is on market pressure and differentiation. These are business incentives as opposed to regulatory legal penalties and processes. The certification is actually more effective and precise than regulation in some cases because, for instance, all certified platforms would be subject to the same kind of process as opposed to what we have now, that sometimes we have certain companies that are being sued, but others are managing to get away without being prosecuted until some other occasion arises. And here we can see how the certification nicely complements regulation because it provides this kind of additional motivation without undermining competition. In fact, it motivates competitors and it doesn't undermine innovation. In fact, it calls for innovation in developing platforms that serve society in a positive way, because this will be rewarded by the certification system. So in any case, this is another approach that has worked well in other contexts, and it's worthwhile considering given that we encounter limitations with regulation and antitrust. So I'll stop here and we can discuss this further once we receive the feedback from the other participants. Thanks.
I will
Thank
just
you,
add,
Odo.
I will just add one thing, just repeating to what Dovev said very, very nicely. I mean, our proposal is a market-based kind of attempt. Okay, so we struggled in the past with the exposed approach. We're struggling with ex ante, and here we will continue with those, but we try to complement it with using the market rather than using regulators in a way that we have succeeded when it comes to problems of asymmetric information. So when you buy a car, they're claiming that it's a high quality, but you cannot observe the car. So what you do, ISO 9001 is a market-based certification process that the companies have adopted that gives certainty to users of cars that the quality is actually high. When it comes to digital platforms, there's a huge problem of asymmetric information. They make claims that finally a third party, a market player, certificator, will be able if we manage to get along this a proposal to certificate for the end user. So you have like a stamp, a quality stamp for good things as well that people can react to, but doesn't rely on the platform themselves making claims that nobody can assess. So it's a market-based solution that would complement the regulation. I just wanted to just say the same thing that Dovev said using the economist jargon.
Thank you, thank you so much for to the three authors for staying in the very strict time frame we have. So now the floor is to Maria Teresa Maggiolino, who will act as a discussant, and I hope she will challenge this proposal and to discuss it into the policy details.
Well, I will challenge the proposal, but not very much, because I have to say that I really appreciated it. And especially because, as Tommaso said, it's really market-oriented. So let me say first what are the points of strength of this proposal. It offers a fresh, original look to regulating digital platforms, because it takes distance from the ex ante, as they said, very one-fits-all rules approach of regulators that regulators have followed over the last few years. And in this way, it takes into consideration the virtuous mechanisms that may work in the market, as they said, in order to involve stakeholders and the digital platforms to be as much transparent as they can. And in this way, the paper offers a framework which is by definition adaptable and flexible enough to cope with the different business models and the different algorithms that each platform may use. So for this reason, I really recommend people to read the paper. But as you said, I'm here as a discussant, so I'm supposed to criticize the paper. Actually, I will not criticize it for the sake of it. I think I will give some food for thoughts, some possible insights to work on for future researches, future papers. And the first one has to do with a kind of classic question. Who certifies the certifiers? So the idea is here we want to work with auditors. I mean, we want to reproduce a system with auditors going through the algorithms of digital platforms and checking whether those algorithms are compliant with not only with the rules, but also with the ethical principles. That's okay, that's very positive, but who should choose the certifiers according to what kind of criteria the certifiers should work? Should we have an accreditation authority for the certifiers? And should the mechanism that the certifiers will use to go through the algorithms be somehow oversighted by an authority of someone else? I'm saying this because, you know, it may happen, especially when we deal with very big companies, that they control the certifiers, or that they create mechanism, kind of perverse mechanism, because of which certifiers cannot be as independent as they could be. So maybe for future papers, authors could focus more on what elements could be used, maybe a kind of hybrid public-private model to choose the certifiers and to check how they should work. And for sure, on this path, I think that may be another idea that could be analyzed or deepened is more technical, and has to do with the kind of technology and technical evaluation criteria that the certifiers should use. Because what the authors are asking the certifiers is a very ambitious task, to go through the algorithms and to open them up. And obviously this can be done, but there are different techniques technical standards according to which this can be done, black box texting, source code audits, explainable AI tools. So I think that this paper could be of interest also for those who want to work on these other issues to understand if there are kind of cause-effect or correlation relations between the kind of business models digital platforms use and the kind of auditors mechanism that certifiers should use to go through the algorithms and to go through the business models to see whether there is something wrong going on. And then let me say other two very quick things. One thing is connected with the idea that right now, especially the commission, as far as I know, is keep on repeating that consumers and users, especially in the digital environment, are not as rational as we use them, as we used to thinking them, right? That they suffer from some biases, such as status quo bias or other kind of cognitive biases, because of which, or due to which, they stay with the same platforms over and over again, even if the platforms provide them with lower quality service. Now, the question for the authors could be, you have framed a market-oriented mechanism, but what if the judges of the entrepreneurs, meaning the consumers, were not good enough to understand what the certifiers say? What if the users were lazy enough or suffer from inertia, and so notwithstanding the certifications, they would keep on working, using, making bargaining with the same bad, maybe, digital platforms? So the question could be, in a digital world where users are supposed not to be as rational as we thought, would a market-oriented mechanism like the certification really work, or we should cope with this issue of consumers and their biases in some way to give credit, to give more room to the certification also in the minds of consumers? And then a final, very brief observation connected with the possibility that digital platforms will endorse this certification system. Well, I really appreciated the analysis that has been done in the paper with all the incentives that should trigger digital platforms to certify their practices and their algorithms. Still, I think that this analysis can be somehow optimistic. And so I would suggest the authors to take into consideration that maybe we could introduce some incentives, or legal incentives for the platforms to use the certification systems. I was thinking, for example, of a rule saying you cannot take part to public procurement of any kind if you have not been certified. Well, this would not be very costly. This would guarantee quality, and this would be further incentive for platforms to embrace this, as they said, complementary voluntary tool of soft regulation. And that's it.
Thank you, Maria Teresa. That was very useful, and I think the authors will reply after that. We have asked Luca Aguzzoni his point of view as a policymaker, as an expert in DMA and preemptive regulation. So do you think that this policy proposal might become something that the Commission might think about. How does it might interact with the current regulation? And do you have other suggestion for
Thank
the
you.
authors?
Thank you, Stefano.
Thank you.
Thank you to the authors of the study. And pleasure to be here because I think it's very important to stimulate the debate on this very important topic that is the regulation of a digital platform. Before diving into my comments, I need to make a usual disclaimer that whatever I say today, also given that it is recorded, it just represents my personal opinion and should not be taken as stating a position of the European Commission. And also, I would like to disclose that I had the pleasure to work with Tommaso for 3 years when he was the chief economist, and so I also wanted to make this disclosure. But of course, we are on different side, let's say today. And as I was saying before, like I think what I really like about this paper and this proposal is also what Maria Teresa said, that this thinking outside of the box and outside the established framework. And I think this paper provides a very, let's say, innovative way of try to solve some of these issues that is, let's say, like more than 20 years that we are trying to solve with not always very good results. So sometimes like trying to take all the same issues with a different approach could provide effective, and I appreciate this proposal. In my short intervention, I mean, there is a lot to unpack and to discuss in this proposal. I will just try to cover like first some positive aspects, then try to make some constructive critiques. Also trying to argue why we still need regulators to play a role. And then I will draw some possible idea for future avenues of research. So in terms of the positive aspects, I think that one aspect that I find very positive is the role of consumers. So like my understanding of this proposal is that the consumers will be the mechanism through which sort of penalties and discipline will be brought to the market. And so like for this market-based type of approach to function, we need to have active consumer that let's say through the reaction, through the decision, they will give penalties to the wrongdoers and reward those that are, let's say, behaving appropriately. But in order to that to take place, we need consumers to play an active role, and that is not only under the scenario of this market-based approach, but also like for regulation like the Digital Market Act to be effective. We do not, we cannot achieve that only, let's say, with the intervention of the regulators, because eventually we also need consumers to take action. So, for example, like with the DMA, we are creating lots of, let's say, like switching opportunities for users, but beyond, let's say, making sure that gatekeepers offer these opportunities, we cannot do much more, and then we need consumers to play an active role. And so if the certification can support consumers' awareness about these topics, can support consumers to be educated about these topics and becoming more active and more conscious in their choices, I think this will be a big benefit to the whole world of regulation of digital markets. And also, what I find positive is that in the DMA structure, there is really at the center this idea of relying on a regulatory dialogue. That is a regulatory dialogue that we are having with the regulated entities, but especially and most importantly, also with all the potential beneficiaries of the regulation, all the, let's say, interested parties like academics, research centers. And so if there are, let's say, if there is emergence of private entities or market-based mechanism that are working the same direction of our digital regulation and try to solve the same problems, I think that would also be very beneficial to stimulate this regulatory dialogue that we have, also because the way we approach the DMA enforcement is really to be open to the community of practitioners, beneficiaries, interested parties, in order to have an open exchange and also learning from what they see in the market. And so like this, I think will be like very important to inform our analysis and to always be up to date with the new practices. So moving to some, let's say, area in which I wanted to provide some, let's say, constructive critique. Let me first, allow me like to first sort of defend the DMA in the sense that the Digital Market Act, that is the instrument that we are enforcing in DG CNECT and DG Comp. And also I should say that we are, let's say, like a relatively big team of 100 people enforcing this tool, but it's still a very new tool. So in the paper, sometimes I was reading some statements that they were already declaring it ineffective, but I would just plead for giving some more years before evaluating its effectiveness. Also because the DMA should be really distinguished from the previous approach that was the ex post approach of the traditional antitrust enforcement. So the DMA, in our view, really takes a very ex ante perspective. Although now we are sort of trying to solve, let's say, ex post some problems that we have inherited. Going forward, the benefit of the DMA will really be that we should arrive earlier on, before certain practices starts to produce their, let's say, harm on the market. And so let's see if this approach will deliver, and we can assess that only in some years. Now is a bit too early. Then moving to some other comments, I think I share a bit also what Maria Teresa said before, that on this market-based approach, it is very interesting, but it remains to me a bit unanswered, the question of who decides what these auditors can do. Because, like, for example, now in the paper, there is a long list of practices that the auditor should monitor, but all these practices are there because they are the sort of the outcome of 20, 30 years of antitrust enforcement in which these practices have been identified. If we want to build instruments that are, let's say, future-proof, of course, practices may also evolve. And so, like, we also need a mechanism of, okay, when there is a new practice or a new business model that may have some harmful practices, who decides what is allowed, what is not allowed, who decides what can get a good score or a bad score. And so maybe I would still see a role of the regulators in sort of giving some a direction there. Also, I would like to mention that even under the DMA, we have the powers to inspect algorithms and also like to retain auditors to do these inspections. So also like from an overall system of, let's say, efficiencies, I'm also like wondering whether it is more efficient to have to sort of ask firms to undergo every year, let's say like a common auditing, or rather to have a more targeted approach where you do the auditing only where you have, let's say, prima facie concern that there could be some issues. And finally, to conclude about ideas of future research, going back to the first point that I made about the importance of engaging consumers, I think that is one of the crucial aspects to me, is that how do we make sure that consumers will play their role? Because also, like in the paper, I think was also mentioned by Maria Teresa, there is, for example, the description of all the privacy paradox, where like consumers should be well aware that they should care about the privacy of their information, but eventually what we see in the market is that consumers, in order to have free products, they're giving away a lot of precious information. So how do we make sure that consumers will play that role, that will be able to understand what is an harmful practice, what is not, and eventually how do we teach consumers maybe like to switch to some products that maybe are less convenient to them in the short term, but maybe will create some advantages to them in the longer term. And then the last point is about how do we audit algorithms? Because that, as I said, in the DMA, we can have these powers, but of course, one consideration that we are making is also how to have the technical expertise to audit these algorithms, especially in a period in which we are moving really to algorithms that are looking more and more like black boxes powered by machine learning and artificial intelligence. So from our perspective, we would be really open to discuss with academia, with private entities, research institute, on how to conduct this auditing.
Thank you, Luca, also for your comments and for your questions. Before giving the floor again to the authors, I would like to add a couple of questions that we received in the chat box. So the first one is from Rebecca Ravalli. She basically asked what is the liability of the auditors in case a negative impact or externality actually occurs. And she says that she's an expert in value chains, and apparently there is some form of liability for certifiers of value chains. And the other question comes from someone I cannot try to pronounce correctly his or her name, but the question is the following. The paper proposes that the identified harms may ultimately evolve into prohibited blacklist practices that could be subject to ex post regulatory enforcement. And this would be how the certification mechanism complements existing DMA ex ante regulation. However, the paper seems not to elaborate on the appropriate design of remedies aimed at correcting for the harm suffered by consumers. Price targeting, censorship, behavioral manipulation, and exposure to online harm. This in circumstances where the paper recognizes the weaknesses of ex post antitrust punitive fines or ex ante non-compliance fines to be paid by the firms. So, apart from cease and desist orders, should restorative restitutionary remedies be part of the relief due to consumers harmed by the blacklist practices? Okay. The two surviving authors have a few minutes to try to answer to all these questions, especially those on market incentives. Dove.
Okay, thank you very much. We really appreciate the feedback and insights that both Maria Teresa and Luca provide, and the audience as well. I'll be very brief because we don't have much time. So the question of who certifies the certifiers, how can we make sure that the inspectors are indeed independent and are qualified, etc. So these are practical questions that organizations like the ISO or the big lab, etc., have dealt with, and we do have attempts of the big tech to intervene also with regulatory process, lobbying, etc. So there will always be such efforts. It's not a reason to avoid this opportunity, and there are conventional practices for screening candidates and ensuring that they have no conflict of interests and that they have the relevant qualifications, and of course providing them with the tools. In the paper, we offered some preliminary scorecards and processes just to illustrate that this is a practical approach, but the first task of the certifying organization would be to specify the standard based on the accumulated knowledge so far, and then every quarter or year to update it with emerging new practices that have been identified. So going back to the issue that Luca mentioned, I think there is quite a synergy between regulation and certification, because the certification process might bring to mind new emerging practices that regulators may want to take a look at, and then the regulators may want to make sure that certain forbidden practices are incorporated in the certification process. So certainly there should be a dialogue between the certifying organization and the regulators. And to the extent that we are able to have an established certifying organization, not a new one, like ISO or the B-Lab, take on this responsibility. So the questions about the reputation of the certifying organization, can we trust the certifying organization? They already have experience, expertise, and reputation, so this would allow to overcome this challenge. If they are not going to volunteer, then probably they'll need to be a dedicated organization set up, and probably the regulators may want to be the ones to help set up these organizations. Other issues like what technologies should be used, especially for inspecting algorithms, etc. There are established tools, especially now there are new AI tools that can help facilitate the work of inspectors. The purpose here is not to fully diagnose the whole platform, but to look at sensitive elements where there are concerns about potential harms, or the company might want to show off how they are able to serve stakeholders in a positive way. So this would be a more, let's say, lean approach. But on the other hand, the certification would run every year. So if this year you didn't meet certain requirements, maybe the next year you introduce certain remedies and you are able to improve your score. And we have to make sure that there are no new practices or deterioration in the stakeholder performance service. Other issues about the customers, and can we trust the customers to actually use the information? So I fully agree with both of you. It's very important to communicate the results of certification. This is exactly what we don't have about the regulation at the moment, because unless it gets to the court where we are exposed to the information that was put forth in front of a judge, we don't know what's going on in this business platform and digital platforms. So here we are able to communicate to consumers, and of course they will not publish the whole report of the inspection, but a summary of the scorecard, so we know exactly which digital platform is performing better or worse on certain grounds, and indeed to simplify it. So it will be like a red, green, red, yellow, green kind of score, or 1 to 10 score eventually, and just whether they got a certification or not. So for example, in the B Corp case, you have to reach 80% to get a certification. This is how it has been done so far. So there will be clear information to consumers. Are they certified or not? What kind of score did they get, so they can benchmark against other platforms, but still they should be mindful about the issues. So if they don't care about privacy and their interests, we assume that some customers do. So much like we have now a lot of attention to green technologies, climate change, we believe there is more exposure and concern in the public, and it's documented that consumers care more about this than they cared in the past. So let me see. I just want to actually share a personal story, because 30 years ago, I was a consultant certifying companies for ISO 9000. This is how I came up with this idea. And since it was early, there was a lot of debate among executives. Should we really invest so much effort in documentation and in certification? Would it really pay off? Today, we have more than 1 million sites across the globe. It's needed to play as opposed to just having an advantage. So even though there is uncertainty early on, as Maria Teresa mentioned, there are ways to incentivize the platforms to certify by providing, for instance, for startups, funding if they are certifying, or as you mentioned, public customers can actually require that certified platforms will be used, like universities will require that, etc. So these are certainly ways to guarantee that the certification idea would work out as opposed to just hoping for it. Tommaso, do you have any other comments?
In 1 minute, since we are running out of time, I just will respond to a common theme between Maria Teresa and Luca, whom I both thank very much, about the role of consumers, no? Because ultimately this is a market-based solution. So, and in particular, Maria Teresa said, with all these behavioral biases, what's going to change with your proposal? This is perhaps, I mean, it's a central point. By way of an example, Facebook now, when they introduce some new rules, you just have to accept them, no? Because you want to communicate, either take it or leave it. You may go and read a document that nobody does, but just accept it. And you don't know what's going to be the implication of giving data to approved third parties, which is what Facebook does. They get your data and they are sold to someone else, but you cannot follow anything. And instead, if the certifier gave you a different information, Facebook claims they do no harm. We found instances where your information has been used, for instance, to affect the mortgage you may get from a company. This is a real case. Black people who had shared on Facebook the secondary school they were studying it, which were, say, in the private areas, that was affecting the credit score that these people, because of being of Black heritage, would get, and they wouldn't get a mortgage. So if the information that is given to you in a different way, your information can be used to affect your mortgage, do you still want to give it? But that's completely different. So a good certification system tells you that. So is this debiasing enough? I don't know. Some people will still say, I don't care, I have nothing to hide. Fine, you told me. But some people say, oh, I hadn't thought about this channel. So this is really about providing information in a much clear way. On liability that Rebecca mentioned, and this is something we haven't no, we haven't studied enough to be honest. It's important, but there is a liability also in 9000 and ISO 9001. So is it the certifier who didn't do their job, or were they supplied with bad information? And then the liability can go in different cases. The last quick comment to the long question of in the chat by Kekana is that we don't really want to impose regulation to correct for harm, but it's if you want, the sanction comes from changes in market share. So it's a market mechanism. If somebody keeps doing bad stuff, then those consumers which realize it and are more sensitive to it, and they can trust a certifier, they would buy less from that company. Finally, as a last comment, I have to react to Luca. Luca said the regulation, and I understand his viewpoint, the regulation is very new, the DMA, so give us some time. I'm getting older, or maybe I've been younger for longer, put it this way. And so I would hope to see solutions in my lifetime instead of, and my worry now is not related to the DMA. You are doing, or the DSA, a heroic job given the resources that you have vis-a-vis the problem at stake. But I'm already observing signals that some of these companies are basically telling to the Commission, you don't like what we're doing, we think everything is fine, see you in court. So I really see a risk that we're starting again a lengthy court battle, which is, maybe not, maybe but if we go that way, supplementing your heroic efforts with our market-based attempt, I think is something we should be doing. Thank you.
May I take my privilege of moderator to ask a final question, especially to Tommaso? Do you think there is the risk of perverse market incentive, that companies are not seeking for certification or for any kind of, I mean, they will show potential investors that they are ready to do whatever is revenue maximizing and not preventing to do anything that might increase the revenues. So it's like a company that does not comply with ESG standards. Maybe they make more money. So if you give certification to good companies, you can create it's the opposite of virtue signaling, that you signal that you're ready to do whatever is necessary to maximize profit.
So the answer is the world going to be ruled by Trump-like policies or not? So if
this is a question we always have to ask
exactly.
ourselves.
So
Every
if
single
we are
day.
in a world like Trump, then all EDI, ESG type of initiatives will just disappear because this is a fundamental question about our democracies. I think I still want to think that there is, and this is Dovev has spent a lot of his research time to that there is going to be some stakeholders which are motivated beyond profit. No, and so if we think this is true, that we have a set of values to which we respond, then the world is a bit less cynical, I would say.
Well, we already have these companies like the B Corps. The idea is to provide them with a reward, with incentive to motivate them. So they're already there, but this would be an advantage for them that they can capitalize on and also grow their market share and become more profitable. There is no inconsistency. As long as there is demand by stakeholders for certain services, protecting their interests or serving their interest, it will be accompanied by market performance, which is exactly the mechanism that is needed for scaling up the certification program.
Thank you. I think we can conclude on this relatively positive note. So I just have to recommend you to read the full paper and the policy brief on you find the policy brief on the YEP website. Also, you can find the Roots That Empower report that we mentioned quite a few times during this presentation. I thank all the speakers for joining us today, and also my colleagues Flaminia Belli and Silvia Tesauro for supporting the organization of the webinar. Thank you again, and see you next time.